say we're very glad that you can address us. And would you like to address us for, say, 30 or 40 minutes, whatever is convenient to you?
Oh, great. Yeah. Thank you very much, Robin. Thank you for the invitation and thank you for the introductions. And it's great to be here again. It's great to see some familiar names. I might not be able to see all the faces. As Robin said, there was a time a couple of years ago when I talked, I remember, about the reform of the United Nations. So it's great to be back again, and I'm very grateful for the invitation. I was asked to talk about the International Tribunal for the Law of the Sea. And interestingly, I was just asking Robin why there was the interest in terms of that, because there are quite a few things that this particular organization is involved in. And hopefully, as we go on, I'll touch on some of the things I feel will be very interesting. And if we do have any questions, I'll try my best to respond to the questions when we have Q&A. So we're looking at today the International Tribunal for the Law of the Sea. And I thought it would be great to just start off with trying to make clear, in terms of the international system, you have a whole range of international courts and tribunals. The International Tribunal for the Law of the Sea is just one of them. Some would say perhaps that's attributable to the fact that there's a feeling in the international system that you must have a wide range of possible courts and tribunals that states might choose to go to. And that would help in terms of encouraging states to actually use what we call pacific settlement of disputes, that's using international courts and tribunals rather than actually going to war against each other. So we have a wide range of international courts and tribunals, like you have the International Court of Justice, sometimes called the World Court, which is the principal judicial organ of the United Nations. We have the International Criminal Court. I mean, like we hear quite a bit in terms of the International Criminal Court. And this court is particularly interesting because the International Criminal Court was set up as a permanent international court to deal with trying individuals and not states for certain crimes against international law. So we have the International Criminal Court. We have some ad hoc tribunals that were set up by the United Nations Security Council to deal with some serious conflicts, interstate conflicts within the former Yugoslavia and Rwanda. We remember the horrible genocide that occurred there to try individuals who were said to have committed those horrible atrocities. Even at the regional levels, we also have, international courts. We have the European Court of Human Rights, the European Court of Justice, the African Court of Human Rights. So there are a whole range of international courts. And the International Tribunal for the Law of the Sea is just one of those courts. We'll be focused on the International Tribunal for the Law of the Sea. And the first thing I would like to mention is that the International Tribunal for the Law of the Sea is an independent judicial body. It was established by the 1982 United Nations Convention on the Law of the Sea, sometimes called the Montego Bay Convention because it was adopted in Montego Bay, Jamaica. And what this convention does is to regulate, basically a whole range of issues concerning the sea. And some have even called it the Constitution of the Sea. It covers, areas in terms of dealing with issues about the what we call the territorial sea, the exclusive economic zone, the continental shelf, the high seas, and the deep seabed beyond national jurisdiction, that basically contains some valuable minerals, and there's a lot even happening even in terms of that. The International Seabed Authority, where I'm a member of the Legal and Technical Commission, is a body that has been set up to deal with that part of the sea. So we see the United Nations Convention on the Law of the Sea dealing with a wide range of issues affecting the sea, deals with environmental issues, it deals with issues in terms of resource management and a whole range of issues. And the ITLOS, I'll use the acronym ITLOS because that's generally what is used, International Tribunal for the Law of the Sea, is a body, one of the three bodies set up by this convention, the 1982 United Nations Convention on the Law of the Sea. The other bodies that have been set up are the International Seabed Authority that I mentioned earlier, responsible for dealing with the area beyond national jurisdiction, managing mineral-related issues affecting that part of the sea. And then you have a United Nations Commission on the outer limits of the continental shelf that is meant to deal with the outer limits of the continental shelf beyond 200 nautical miles. So the ITLOS is the third body that has been established by this convention. But it's important to point out that though this convention is called the United Nations Convention on the Law of the Sea, and obviously it was negotiated under the auspices of the United Nations, the United Nations called a conference in 1973 that involved a whole range of participants. You had states involved, you had international organizations involved, you had members of the civil society involved, and there was a long period of negotiation that went on from 1973 to 1982 when the convention was adopted. So there was a lot put into that. And though it's called the United Nations Convention on the Law of the Sea, it's important to point out that the tribunal, the ITLOS, set up under the auspices of this convention is not an organ of the United Nations. It is a different international organization, though it maintains very close links to the United Nations. We might want to call it one of the institutions or international organization that falls within what we'll call the United Nations family. But in reality, it's not part of the United Nations proper. The International Court of Justice that I mentioned earlier is part of the United Nations because it's a principal judicial organ of the United Nations, but the ITLOS is an independent judicial body from the United Nations. But it maintains close links with the United Nations. For instance, it's concluded agreements in terms of cooperation and relationship with the United Nations. This establishes a mechanism for cooperation between the United Nations and the ITLOS. And what it also has, it has observer status in the United Nations. At the 51st session of the General Assembly of the United Nations, the ITLOS was granted observer status. And what that means is that it can actually participate in the meetings and work of the United Nations, and it can be involved in the discussions, but it cannot vote in terms of the United Nations General Assembly. And so what we see is that the president of the ITLOS every year goes to the General Assembly because there's a standing agenda in terms of the General Assembly dealing with oceans and the law of the sea. So every year, the president of the ITLOS would do a presentation before the General Assembly, just giving an idea of what is happening in the ITLOS and how it is contributing towards the development of the oceans and the law of the sea. It does that every year. So there's a relationship, but it's important to always understand that it is a separate international organization from the United Nations. It's based in Hamburg, Germany, and it has, that's where it meets as its principal place of sitting. But the rules allow it if it's absolutely necessary. They rarely ever would do that. But if it's absolutely necessary to decide on a case, they might move from place to place. But I can't recall them ever doing that, but there's provision even for that. It's composed of 21 independent members, the judges, who are elected by a secret ballot by the state parties to the United Nations Convention on the Law of the Sea. And each state party may nominate up to 2 candidates. And basically, I think I was meant to okay, we can ignore from persons enjoying, because that was meant to be the second in the second box, because they can choose a maximum of 2 candidates. And the qualifications of those candidates is that first, they must enjoy the highest reputation for fairness and integrity. And then secondly, they must be recognized as having competence in the field of the law of the sea. So those are the 2 requirements, really. And once they have this qualification, so to speak, those state parties may nominate a maximum of 2 candidates. You find out that when the elections take place, no 2 judges can come from the same nation. So each state, as they nominate 2, the best that can happen is that one of those 2 candidates will be picked to be a judge in terms of the ITLOS. And in choosing these 21 independent judges, the whole idea is to try as much as possible to try and represent what we regard as the principal legal systems of the world. So we're thinking in terms of the common law system, the continental system. You're thinking in terms of, I mean, like in terms of like socialist type legal system. You're thinking in terms of also maybe Islamic states, in terms of Islamic legal system. The whole point of this is that since there are a wide range of states that are likely to come before the tribunal, the ITLOS, that the judges should have a sense in terms of this variety of legal system. They should have judges who are members who would have an idea of some of the issues that may arise in this different legal system. And the way the election usually would go is that there's always an attempt to ensure that there's what is called the equitable geographical distribution based on the United Nations, geographical groupings for elections. The United Nations, I'm sure, as we well know, generally uses, some would say in a way that is still a fallback in terms of the Cold War era. And some have suggested that maybe there should be a looking forward in terms of that, but it still use the same regional geographical grouping for the sake of elections, with the ITLOS also uses. So you have the African states, and then you have the Asian states, then you have the Eastern European states. That's what I mean by a fallback in terms of the Cold War era. And then you have the Latin American and Caribbean states, and the Western European and other states. So they ensure that basically these different regional groupings are represented amongst the 21 judges of the ITLOS. The judges are intended, they're meant to be independent. So the idea is to try and give them a long period of time to serve as judges. And the hope is that that would sort of cocoon them and protect them from, unnecessary interference from their national state. So they're elected for 9 years, and they can actually be re-elected even after the 9-year term expires. So that's in terms of the membership of the ITLOS. What the ITLOS does is that it can either sit as a court having a plenary session with all the 21 judges sitting to determine a particular case. But on the other hand, the states might choose and they may prefer to have a smaller number of judges to decide particular cases. So while the ITLOS can actually sit in terms of all the judges sitting, it also has what we call the chamber system. So you have various chambers in the ITLOS. You have what we call the chamber of summary procedure. And the idea of this is to deal with cases speedily. If the parties to the case basically are determined to have the case decided speedily, then the president of the ITLOS would want to convene the chamber of summary procedure. And the idea of this is to to have the chamber hear and determine the cases by what we call summary procedure if the parties so request. And this helps in terms of dealing with it very speedily. And you have a limited number of judges that constitute this chamber of summary procedure. It has 5 members, and they choose 2 alternates just in case one thing or the other happens to any one of the 5 members, so that the alternates can step in. And remember, it's meant to try and deal with the cases as quickly as possible. And then you have the Chamber for Fisheries Disputes. And the whole idea of this is to deal with disputes that relate to conservation and management of marine living resources, which the parties, again, if the parties choose not to have all the 21 judges, they might want to bring those sort of cases before this chamber because it's a smaller chamber. It's constituted by 9 members of picked out of, they're appointed from the 21. And then you have the Chamber for Marine Environment Disputes. And the whole idea of this chamber is to deal with disputes relating to the protection and preservation of the marine environment. And again, the parties agree and they decide, well, we don't want all the 21 judges. We want just a limited number of judges. And this chamber also is made up of 9 members that have been appointed. And then you have a chamber that deals with maritime delimitation disputes. So when there are disagreement in terms of states, in terms of how their maritime boundaries should be delimited, and again, if they choose not to go to the 21 judges, the plenary sitting of the judges, they might choose to go to this chamber, which is again, constituted by a limited number of the judges. 9 members are appointed to deal with this, and they just deal with disputes that relate to maritime delimitation. And beyond this, I mean, like the tribunal also has the powers under its rules to set up special chambers as requested by the states. Again, recall what I said, the whole idea in terms of the international system is always to try and make the process of judicial settlement of disputes among states to make it as flexible as possible. So states are encouraged to use whatever system they feel is more convenient to them. And apart from these special chambers and the other chambers, the special chambers and the other chambers I've mentioned, there's a very important one, the Seabed Dispute Chamber. And the whole idea of the Seabed Dispute Chamber is to deal with disputes that arise in relation to activities in the deep seabed beyond national jurisdiction. As I mentioned earlier on, the International Seabed Authority has been established to manage that part of the sea. So if there are disputes in relation to that, the idea is that those disputes will be brought before this disputes chamber, the seabed disputes chambers, made up of judges who are thought to be very experienced in terms of dealing with issues in relation to the deep seabed beyond national jurisdiction. And this chamber is composed by 11 judges, and it has handled a very, very important advisory opinion dealing with the issue of, the responsibility and liability of states, in relation to activities within the deep seabed beyond national jurisdiction. The whole idea was to understand what exactly the sponsoring states that sponsor contractors, even to go and carry out mining activities in those areas. Right now, exploration is being done, and there's a lot of debate in terms of whether that should progress to exploitation or whether there should be a moratorium in terms of exploitation of the deep seabed beyond national jurisdiction. So basically, what the chamber is meant to do is to address these issues. If there are disputes, is brought before the chamber, and the advisory opinion basically was to try and clarify in terms of what are the limitations, or what are the extent rather of the responsibility and liability of states that sponsored entities in relation to their environmental responsibility and liability. And the Chamber, in its advisory opinion, went into a lot of details in terms of big issues like, environmental impact assessment, the whole idea that it has become a rule of customary international law, and it's really important that that should be a central part of the International Seabed Authority dealing with the issue of activities in the deep seabed beyond national jurisdiction. It dealt a lot with the precautionary approach or principle, and it looked at how important it is for best scientific evidence to be available in terms of carrying out activities even in the deep seabed beyond national jurisdiction. So those are in terms of the structure of the ITLOS. The ITLOS has jurisdiction in two broad areas. It has jurisdiction in terms of what we call the contentious jurisdiction. So when you have a dispute between two or more parties in relation to either the interpretation or the application of the convention. Remember, I mentioned the Convention on the Law of the Sea, the United Nations Convention on the Law of the Sea deals with a huge range of issues affecting the sea. So sometimes you might have disputes between more than one party in terms of this issue. And when that comes before the ITLOS, it's coming under its contentious jurisdiction. But there's another jurisdiction that the ITLOS has. It has the jurisdiction to give advisory opinion. So it can have a situation where either a body in relation to the Seabed Dispute Chamber I mentioned earlier, if the International Seabed Authority, one of the organs within this International Seabed Authority, basically is not clear about a particular legal issue, it can bring an advisory opinion before the Seabed Dispute Chamber. And also it allows also in cases where there are agreements outside the United Nations Convention of the Law of the Sea that allows certain organizations to bring, a request for an advisory opinion to the ITLOS. It allows the ITLOS to be able to address that. And one of the things I'll just go touch on this a bit more. We see that over the years, the ITLOS has been able to deal with quite a bit of cases dealing with this contentious jurisdiction. It has had a whole range of cases coming before it. And the greatest number of cases that it has had to deal with in terms of its contentious jurisdiction is in relation to what we call an application for prompt release of vessels. So, I mean, like there are situations where a particular vessel from a flag state may be arrested by another state. And so the flag state can come on behalf of that vessel before the ITLOS under its contentious jurisdiction, making a claim against the arresting state and requesting that the ITLOS would make an order for the prompt release of that vessel. And the whole idea is recognizing the fact that for as long as a vessel is detained, there'll be serious loss of profit. So the ITLOS steps in situations like that and would listen to the argument of both parties. And if there's a potentially good reason why the vessel has been detained, what the ITLOS would do is to make an order for prompt release, but would request that the flag state would put together a sort of bond, monetary bond, and would deposit it somewhere that the ITLOS would order, so that if at the end of the day the case is decided and it's found that the arrest of that vessel was justified, then basically it can use that bond, monetary bond, to compensate the arresting state, and that's quite a lot of what it deals with in terms of its contentious jurisdiction. But it's also dealt with some other, cases in its contentious jurisdiction. as a plenary body, all the 21 judges sitting, it has had to deal with a case brought by Mauritius against the Maldives. And the whole idea of this case was basically to try and determine the delimitation of maritime boundaries between these two states. And the ITLOS has basically had to deal with that case. The ITLOS has also had to deal with, dispute in terms of, again, maritime boundary delimitation between Ghana and Cote d'Ivoire. But interestingly, with this particular one, the two states basically preferred a situation where they prefer that a chamber would determine or would hear the case. So with this particular case between Ghana and Cote d'Ivoire, which was dealing with delimitation of maritime boundaries, the ITLOS was requested to set up a special chamber to address the dispute between these two states. And it went on to give a decision in terms of that. So we've had quite a number of, cases under the ITLOS contentious jurisdiction. In terms of its advisory opinion jurisdiction, it has had three very important advisory opinion that it has given an advisory opinion on. It has given an advisory opinion on a request by a sub-regional fisheries commission based in the African continent. And it gave the advisory opinion on that. It's also given an advisory opinion, as I mentioned earlier, on the responsibilities and obligations of states sponsoring persons and entities with respect to activities in the area. That was a very important one as well. And in recent times, it has also given an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law. That's the most recent advisory opinion that it has given. I must mention that the difference between the contentious and the advisory opinion jurisdiction is that with the contentious jurisdiction, as I mentioned, there are two disputing parties or two or more disputing parties. And when a decision is made, the decision is binding on the parties to the dispute. But with the advisory opinion jurisdiction, it's slightly different. What is done is that some questions are put before the court, and the whole idea is to request for the opinion of the court, a specialist in ocean matters and the law of the sea, to give an advisory opinion on the legal opinion, or the legal position rather, on those questions. So technically it's not binding, but because it's given by the ITLOS, which has a good reputation as a court directed towards dealing with law of the sea and ocean matters, whenever they make an advisory opinion, or whenever they give an advisory opinion, rather, it's usually taken very seriously. And that's why some bodies will go before even the ITLOS to seek for the advisory opinion of the ITLOS. And usually what happens with the advisory opinion is that once that is brought before the ITLOS by certain bodies that have the powers to request for those advisory opinion, what the ITLOS would usually do is to invite interested states to come in and put forward arguments that are relevant to the questions that have been asked. They also usually would invite what we call friends of the court, members of civil society who are interested, and they also would put together their arguments and bring this before the court. And the whole idea of it is for the court to hear a variety of opinion, and based on that, the court responds and writes out its advisory opinion in terms of what exactly the position is in relation to the questions that have been asked. Another point I'll just quickly mention in terms of the advisory opinion jurisdiction is that under the United Nations Convention on the Law of the Sea, it's clearly stated the seabed dispute chambers can take advisory opinions requests from the International Seabed Authority and some of the organs that constitute the International Seabed Authority, but also allows for, bodies that have treaties that confer specifically on these bodies the right to request for advisory opinion from the ITLOS. And this is particularly relevant because as we look at the issue of the very recent advisory opinion that has been sought, we would see that this is relevant because this advisory opinion was sought by a body called the Commission of Small Island States on Climate Change and International Law. And I'll just talk about this a bit, the advisory opinion, this recent one. And after that, I think I'll just wrap up so that we can take questions and answers to clarify some of these things. So it was brought by a body called the Commission of Small Island States on Climate Change and International Law. And this body was set up under a treaty entered into by some small island Pacific states. And in this treaty, there was provision in the treaty that allowed this body to seek for advisory opinion from the ITLOS. And what happened was that in 2002, this body, this commission, the Commission of Small Island States on Climate Change and International Law, they actually sent a letter to the registry of the ITLOS requesting for an advisory opinion on the whole idea of climate change, international law, and how that relates even to the law of the sea and how it relates to the United Nations Convention on the Law of the Sea. And because this body under the treaty setting it up had the powers to do that, the ITLOS basically found that it had jurisdiction to respond to that request for advisory opinion. And it gave some very interesting advisory opinion in terms of it. I'll just mention some of it and then quickly wrap up in terms of this so we can have questions if we have any in terms of what we've talked about or any other issues perhaps relevant to the ITLOS. The ITLOS gave some very interesting decisions, and some of the things that basically came out of the advisory opinion of the ITLOS, which was delivered in May 2024, was that countries have an obligation to reduce their emissions to protect our oceans. It also mentioned that countries' climate change action may need to go beyond the International Climate Treaty, the Paris Agreement, for them to meet their legal obligations on marine protection. It wasn't ignoring the Paris Agreement, but it was saying also under the United Nations Convention on the Law of the Sea that there were obligations under the convention for even the state parties to the convention to recognize that they had to take action to meet their responsibility, even to ensure that they're doing enough in terms of climate action. And it talked about the fact that basically that countries have, it said countries with the greatest, historic responsibility for the climate crisis must step up and do more to address pollution from green gas emissions that obviously have a huge impact in terms of the sea and the oceans, and that they needed to do more than states with smaller footprints. And of course, we would recognize that falls under the principle of common but differentiated responsibility. And so these are some of the things that the tribunal mentioned. I'll just mention some others. It talked about the fact that the United Nations Convention on the Law of the Sea places an obligation on states to take all necessary measures to prevent, reduce, and control pollution of the marine environment. And in the context of climate change, that this amounts to a duty to reduce greenhouse gas emissions from all sources, and not just only in terms of maritime activities such as shipping. And it also mentioned in relation to developing states, and I'll just pick on that. It says that with developing states, if we just bear with me, I'll just call that up and talk about that. Okay. Yeah. Well, while there's common and differentiated responsibility, also the tribunal, the ITLOS recognize that the developing states also had a part also to play in terms of that. Of course, recognizing that there was common and differentiated responsibility. And it talked about the fact that states must take measures to reduce greenhouse gas emissions in accordance with their capabilities. And the whole idea was to reflect equity between developed and developing states and to be consistent with the principle of common but differentiated responsibility. And it also recognized that under the United Nations Convention on the Law of the Sea and the general rules of international law dealing with climate change, developed states have a duty to assist developing states in their efforts to address marine pollution through capacity building, sharing of scientific expertise, technology transfer, preferential access to funding and support for international organization. So the ITLOS basically, I mean, like the advisory opinion was really showing that climate change is real and that there was a very urgent need to address it. And we probably are aware that apart from the ITLOS, there's currently pending at the International Court of Justice another request for an advisory opinion related to climate change. And we also have in terms of, also I believe it's in terms of the American Court of Human Rights. Also, there is an application in terms of it. And the feeling is that this advisory opinion, both the ITLOS currently and hopefully when the others are decided, that they help to strengthen in terms of the whole, move to ensure that states are carrying out their obligation to ensure that they are doing enough to cut down on greenhouse emissions and doing all that they need to do to ensure that their responsibility under their climate change action are actually being carried out. So I'll stop at this because there's a whole range of things we can say about ITLOS. I don't want to get too technical in terms of it, but I think we've said enough in terms of this. And if there are questions, I'll be happy to take the question. Thank you once again for inviting me to give the talk.